Hello everyone and welcome back. In this video, I want to educate you about the Marchman Act and the right to counsel. Now, if you've watched any of my Baker Act videos, you'll know that, I've told you and talked about the right to counsel in a Baker Act proceeding. So if the facility decides to file, and only if they actually do file, do you get a lawyer. So in theory, that means you could be sitting there for days, potentially even weeks, and you don't get to see a lawyer. Because remember, under the Baker Act, once you're taken there, nobody actually knows you're there. And when I say nobody, I mean there's no oversight. Nobody's watching the facility to make sure they do it right. And unlike in a criminal case, where if you get taken to the county jail and you cannot post a scheduled bond, or you've been arrested for a non-bondable offense, such as domestic violence, within 24 hours, you're going to go see a judge. And one of the things the judge is going to address with you is the right to counsel. But if you get Baker Acted, right, you don't automatically get that right to counsel. You only get it if they file to keep you, or if you or a family member on your behalf hires a private lawyer to represent you to get you out before you even get to the point where you're now in front of a judge. And it's not whether or not you're going to get stuck. It's just a matter of how long you're going to get stuck for, which is why if you've watched any of my Baker Act videos, I'm really adamant about fighting to get out as soon as you are detained under the Baker Act, even if it's potentially a legal detention. You don't want to be there, okay? But that right to counsel also applies under the Marchman Act. And if you want to look up statute 397.681 subsection 2, it talks about the right to counsel. A respondent has the right to counsel at every stage of a judicial proceeding relating to a petition for his or her involuntary treatment for a substance abuse impairment. However, the respondent may waive the right if the respondent is present and the court finds that such waiver is made knowingly, intelligently, and voluntarily. A respondent who desires counsel and is unable to afford private counsel has the right to court-appointed counsel. So typically what happens is that once there's a hearing, and there can be a hearing on both a request for an assessment order and a request for treatment. Now, a lot of the time we're going to file, if not most of the time, we're going to file or make the request for an order for assessment on an emergency ex parte basis, meaning there's not going to be a hearing, right? So if there's no hearing and it's done on an emergency basis, the respondent, the patient, isn't going to know about this, which means that the right to counsel doesn't kick in yet. It only kicks in once there's a hearing set. Now, if the court sets a hearing on the request for an assessment order, great. The right to counsel is going to get addressed at that point. But if we are now at the treatment services hearing, because the initial assessment was initiated on an emergency basis, that's the point at which the court is going to talk about the right to counsel. Now, a bit like in a criminal case, the court will do, sort of ask the person to fill out documentation about their financial situation, right? Because we don't want to give a court-appointed lawyer to somebody who has the financial resources to go and hire a private lawyer. But here's what's really neat about this. Think about this, right? This Marchman Act statute is civil in nature, right? It's not a criminal case. It's civil, filed most of the time, depending on the courtroom. The county. It's going to be filed in the county that you're located in the probate division of the clerk of court. So it's not criminal. It is civil in nature, but some of the constitutional protections that we would associate with a criminal case, for instance, the right to remain silent, the right to counsel, the right to make the prosecutor, or in this case, the petitioner, meet the burden of proof, which is a bit lower in a Marchman Act case versus a criminal case. But you get the idea. So some of the protections that we would associate with a criminal case also apply to a Marchman Act case. And here's why. Because what we're really looking to do, if we're filing this against somebody, we want to take their liberty away. Now, we're not locking them up like we would in the county jail, but we are restraining them. We are taking away their liberty and telling them, look, you're going to go to treatment and this is where you're going. And if you don't, there's going to be consequences for that. One of which can be a period of time in the county jail for violating the court's order for treatment. So even though this is civil in nature, yeah, your loved one's going to, is going to get a lawyer, right? Whether they're going to hire one or the court's going to give them one, which is why I have said in the past that if you file your own Marchman Act and you do it without a lawyer, you're going to be at a significant disadvantage. Now, we've litigated these cases as petitioners counsel all over the state. I've also been hired to do, be respondents counsel. Not very often, but every once in a while. But, one of the things I've noticed is that when we file these cases, most of the time, the respondent is going to get a court-appointed lawyer. And I'm going to tell you, these court-appointed lawyers, they are really good. And I mean really good. I mean, think about it, right? They are handling these cases on a weekly basis over and over and over again. I mean, you can't but help get good at these things. And I'm going to tell you, every court-appointed lawyer who gets appointed to these Marchman Act cases that I've ever encountered is really good. So if you have a really good lawyer representing your loved one who's familiar with this statute and the rules of procedure and the rules of evidence, and you don't have a lawyer, do you think that you can win this case? I think the chances are somewhere between slim and none. I'm not saying it can't be done. I'm just telling you that it's very difficult. So you should hire a lawyer to represent you, because if your loved one's got a lawyer and you don't, you're probably going to lose the case, if you even get this far to the point where the court appoints a lawyer. Anyway, I wanted to share that with you. I appreciate you tuning in. If you have any comments or questions, please post them. I read all of them, and I typically respond within 24 hours. I would appreciate a thumbs up, and if you could subscribe to the channel, even better. And with that said, I will see you in the next video. Bye-bye.